If you're here, it means you're probably wondering whether or not you should put your home and other assets in your kid's name. Well, in this video, I'll tell you why many people have been told to do it or consider doing it, why we tell our clients to never do it, and what you should consider doing instead. Hi, I'm Chuck Roulet. I'm an attorney licensed to practice in both Minnesota and Florida. We have an office in Minnetonka serving our clients and their families in the Twin Cities and throughout the entire state of Minnesota, as well as an office in Venice, Florida, just south of Sarasota, serving clients and their families in the Gulf Coast and throughout the state of Florida. And in today's video, we're going to discuss why we tell our clients to never put their kids on title to their assets and what they should consider doing instead. So again, one of the most common questions I hear from clients is whether or not they should put their home and other assets in their kids' names, or frankly, just give everything outright to them. Well, usually they're asking because someone told them at some point that if they do that, it means their family's not going to have to go through probate upon their passing, and or that doing it will protect their home and savings if they need to go into a nursing home. Well, unfortunately, if you put your kids' names on things, it actually tends to cause more problems than it solves. And we're going to go through some of those right now. The first one to be aware of is, well, there's gift tax issues. At the time of this video, you can give away $17,000 per person per year without needing to file a gift tax return. Now, if you put your kids' names on your home, for example, you've actually given them a gift of the present value of your home. And since that likely exceeds $17,000 in value, you're going to need to file a gift tax return. But that's not even what some of the biggest issues we run into. For example, you've now created a potentially large capital gains tax issue for your kids. Now, to illustrate this, let's assume for a moment that you paid $100,000 for your home when you purchased it 30 years ago, and perhaps it's now worth $350,000. Well, your basis for tax purposes is what you paid for it, plus any improvements you made over the years, but let's just call it $100,000 for our example. Now, if you put your kids on title, you're actually giving them your basis of $100,000 for tax purposes. Now, when you pass away, since your kids are listed as the joint owners, well, they'll actually own the home and not have to go through probate because they were the surviving joint owners on the title. That's the advantage to this. However, now, when they sell the home for $350,000, they're going to need to pay capital gains tax on that $250,000 of gain. If the capital gains tax rate is, say, 20% at that time, that's a $50,000 tax bill. Now, if instead, rather than putting them on title, if you had given them the home after your passing, say via a will or a trust or another planning mechanism, for tax purposes, the basis in the home would have adjusted to the fair market value at the date of your death. In our example, the $350,000, and you'll have saved them $50,000 in taxes. So another example of this is I once had a woman contact my office as, unbeknownst to her, her mom was in the presence of selling her home after the passing of her dad. And unbeknownst to her, her parents had put her on title to their home. Now that her dad had passed, her mom was wanting to sell the home and move into something smaller and closer to her daughter and the grandkids. And so one day the title company calls this woman to obtain her social security number and bank information so that they could transfer a check for her share of the sales proceeds and then report the gain to the IRS for tax purposes. And she called me and she says, hey, what's going on? And I explained to her, I said, since your parents made you an owner, okay, when the home is sold, that's not your primary residence, you're going to have to pay capital gains tax on the proceeds from the sale. And she was concerned where the money was going to come from. And I said, well, you're going to take a portion of the proceeds and you're going to pay the capital gains tax. And then she tells me, well, that's my mom's money and she needs it to purchase the new home. And then I had to explain to her that as far as the IRS and the tax laws are concerned, it's her money. She'll pay the capital gains out of her share of the proceeds. However, if she then gives some of that money or even all of that money back to her mom to purchase the new home, she's now going to have to file a gift tax return on that. And I told her, it's a running joke how often I say this in any given day or week here in the office. I don't make the law. I just tell you what it is, how to work with it, how to make it work for your benefit. And yes, a lot of it's nonsensical. Now, I'm not saying don't do gifting. Gifting, when done as part of an overall estate planning strategy, can be useful. However, the law is tilted towards giving things to your kids after your passing rather than while you are alive. Now, another reason you may not want to put your kids on title to your home and other assets is you may have just given somebody an interest in that asset that you didn't intend. So for example, depending on your state of residence, spouses usually automatically receive a legal interest in any assets owned by their spouse, even if they themselves are not listed on the title. For example, in Minnesota, spouses automatically have any interest in real estate owned by their spouse, even if they're not in fact listed on the title. As an example of this, I once had a woman referred to me by her daughter's divorce attorney. She had apparently taken the advice of a previous attorney who advised her to list her daughter, put her daughter on title to the home with her bank accounts and other assets. Unfortunately, now that her daughter was getting a divorce, her soon-to-be ex-son-in-law was asking the court to obtain his share of the assets her daughter now owned as part of the divorce proceeding. So again, another caveat, warning about not putting your kids on assets. Another issue, if you put your kids on assets, those assets are not protected for them. So again, much like in the last example, if your kids get divorced, they get sued, they have a job loss, a medical emergency, since they now own those assets, they may be fair game for their now, soon-to-be ex-spouse or other third parties. Just like in the last example, you're now subject to the claims and issues of your kids. Again, if the person you're making an owner has creditors or other issues, you get invited to their party. Now, here's a really good example of this. In the 90s, well-known actress and model Jill Goodacre, she put her dad on her checking and savings accounts so that he could pay bills for her while she traveled. However, Jill didn't know that her dad had creditors. And when the creditors located the account with his name on it, they were able to clean out the accounts in order to satisfy the judgment. And apparently some $80,000 of Jill's money went to her dad's creditors. To make matters worse, the transfer was deemed a gift from her to her dad, and she was now required to file a gift tax return with the IRS for the gift she gave to her dad. Another issue is the transfer may disqualify you now for benefits you may otherwise have been entitled to. Now, people often hear that they can transfer the home and assets to their kids, and if they do that, it will protect them in the event they ever need long-term care and need to go into a nursing home. Well, the fact is, the rules for qualifying for benefits are extremely technical and must be strictly followed. And in fact, when done incorrectly, you may discover that not only are your assets not protected, but you may not now qualify for benefits you otherwise would have been entitled to. Again, that's why when you're trying to protect assets from long-term care and nursing home costs, it's really important to work with an experienced attorney in order to protect your assets. So what should you do instead? Well, if you want to avoid probate, you should consider using a trust or trusts. A trust can make it easier and less expensive for your family to manage your assets during any period you may be incapacitated, and to transfer assets upon your passing while avoiding all of the issues we've just discussed. The trust can also be designed to protect the money you leave for your children and grandchildren in the event they get divorced, get sued, have a medical emergency, a job loss, and more. Lastly, with careful planning, you can actually obtain the care and benefits you or a spouse may need and be entitled to without losing your home and life savings. However, as I said before, the rules are strict and complex, and you should work with an experienced attorney. If you would like to learn more about why your existing plan or lack of one may fail just when your family needs it most, and how you can put a plan in place to make it as easy and inexpensive for your family while protecting your assets, I'm actually going to be hosting a free online masterclass. I'll be revealing what you need to know about powers of attorney, living wills, healthcare directives. We'll go through the pros and cons of will and trust. We'll talk about tax minimization strategies, how to protect your assets that you leave for your family in the event they get divorced, get sued, so much more. There's a link in the description down below. You can click on that. Again, it's a free masterclass. And if you'd like to learn more about how you can protect your home and life savings from long-term care and nursing home costs, download my free guide, Save My Home, How to Protect Your Home and Life Savings from Long-Term Care and Nursing Home Costs. Again, there's a link in the description below, or you can visit saveourhome.com. Again, this is a free guide, and we'll walk through the strategies and tactics for saving your home and life savings from long-term care and nursing home costs. And if you have questions about powers of attorney, living wills, healthcare directives, wills, trusts, or how to protect your assets, post it in the comments section below, and I may answer it in a future video. Again, make sure you check out the links to the online masterclass and the free guide, and we'll see you soon. Be well.